Hey everybody, Scott Shoemaker here, and I am an estate planning attorney in Cedar Rapids, Iowa. And one of the questions I get from time to time is, what happens if I don't have a will? And that's a very good question. Now, ordinarily we think of a will as a way to dispose of your stuff, your personal property and real estate, and maybe the cash that you have on hand at the time that you would pass away. But there are other things that can be addressed in a will as well. The most important thing, perhaps the most important thing, even more important than the distribution of assets, is the care of minor children. Guardians can be appointed by a will. And typically, if a person does not have a will, the children will pass through the foster care system and end up. The foster care system gets very complicated, but typically they try to place the children with family whenever possible. But sometimes that ends up not being the family member that you would choose, because oftentimes it's the family member that is the geographically nearest to you, rather than the one with perhaps whom the children are the most familiar. But the children will be taken care of by the state through foster care system. So let's talk a little bit more about what happens to your property. And it depends on whether or not you have, whether you're survived by a spouse or not, and whether you have children or not. The state has a plan. It's all laid out in the Iowa Code. It's a little tricky. I can sort of draw you a chart, but just to summarize some general considerations. So starting with whether you have a spouse or not. So if you have a surviving spouse at the time of your death, and Iowa law recognizes both traditional opposite gender marriages and same-sex marriages are the same for these purposes, at least at the time of making this video. So if you have a surviving spouse, then they will take a share of your estate. The share of that is determined by whether or not there are children. If you have a surviving spouse and all of your children are children of you and your spouse at the time of your death, then your spouse will take your surviving spouse will take 100% of all of the assets of your estate. They will transfer to your surviving spouse. It gets a little trickier if you have children from more than one relationship. So if you were perhaps married twice and you have children from multiple marriages and your second spouse has not adopted the children from the first marriage, then the estate will be divided. And the surviving spouse will get the first $50,000 in assets from the estate. And then they will be entitled to 1/2 of all of the remaining assets. So if your estate is relatively small and is, say, $150,000, just makes very easy math here. Your surviving spouse would get the first $50,000. And then they would get 50% of the remaining assets, or another $50,000. So they would inherit $100,000 of the $150,000 of your estate at the time of your death. And the children that are not the children of your surviving spouse then would divide in equal shares the remaining 1/2 of the estate, or the remaining $50,000 in that $150,000 example. If you do not have a surviving spouse, then all of your children would divide your estate equally. So if you had a $150,000 estate and 3 children, each of the children would get $50,000 of the value of your estate. If one of your children were to predecease you, that is to pass away before you did, then your your grandchildren would inherit your child's share, dividing it equally among the grandchildren. If you do not have any children, then your parents, if they survive you, would inherit your estate, and or your siblings would, if your parents did not survive you, or your siblings' children. So we're getting pretty distant here, because those would be your siblings or your nieces and nephews. If your parents, you have no children, your parents are gone, you have no living siblings, then it would go to your grandparents and their descendants. So that would be aunts, uncles, along those lines. So it can get pretty far spread out. What's important here is there's no provision for lifelong friends, for unmarried partners, or for for other people that you would want to see taken care of at the time of your death. And so this is why many people prefer to approach approach a plan, to have a plan that overrides the scheme that is set out by the state. And as always, if you have questions, you can leave a comment below this video, and appreciate you taking the time to watch, and we'll talk again real soon.